Yes.
My lords and my lady, we do have some points to reply. We are acutely conscious of the time and grateful for the fact that we're able to start at 10 to 2. We're both going to deal with the reply, if we may, divided between us in the same order in which we took the points in our own submissions. Mr. Swoboda will go first on a couple of points, and I will then conclude on those which I dealt with, and I'll sort of close at the very end. We are entirely, as I say, aware of the time. We will be as brief as we possibly can be, while doing justice to a response to Mr. Platt's points, but grateful for my lady's indication that we can be as brief as reasonably necessary for the case.
That's the most important thing.
Very, very grateful indeed for that. Understood. Thank you.
Yes.
My lords, my lady, may I start with the point which my learned friend, Mr. Platt KC, made in respect of McGee. He dealt with this quite briefly, and I intend the response to be equally as brief, if not briefer. The principle that I seek to rely on is that the creator of risk bears the evidential uncertainty, because to do otherwise is to create an unfairness and injustice. That was a principle which was articulated by Lord Wilberforce in McGee, which is a separate and distinct case from Fairchild, and it has not been overruled, and it is good law, and which was, in any event, that explicit principle was explicitly endorsed by the majority in Fairchild, and I've already given you the references, so I won't give you those again. It is not, of course, a principle which is limited to asbestos or personal injury cases. It applies to a wider context, and all I am asking for in those circumstances is for the application of a principle of law to avoid an injustice and unfairness on the facts of this case.
Mm-hmm.
The next point that I want to deal with, if I may, is that method 2 is not a version of method 1 or vice versa. There was some indication by my learned friend that because it is possible to have a linear slope in Hodgson and Darnton's extrapolation to low doses, that makes the process similar or equivalent. It is not. The starting point for method 1 is risk is proportionate to dose, and that, my lords, my lady, is a principle of epidemiology, and I make no apology for that. But thereafter, it is bespoke to Elaine. The tortious exposure is based on the evidence that comes before the court, and the judge has to make findings of fact as to the amount of exposure. The counterfactual exposure is also based on evidence. The evidence that comes before the court and the findings of facts, aided by expert evidence, but grounded in the evidence before the court. So in this case, the fact that the judge made that the finding the only known exposure was at Fawcett's garage. If you contrast that to method 2, the starting point for the tortious risk is to extrapolate from Hodgson and Darnton from between 100 to 1,000 times to make an assessment. That's the epidemiological basis for that, is that it's better to use the Hodgson and Darnton data set than the epidemiological principle or the epidemiological, as it's put in Hodgson and Darnton itself, the scientific compromise that risk is proportionate to dose. And the counterfactual risk for method 2 uses a population statistic derived from a data set from Peto and Rake, and then further developed by the respondent in this case. There is no link to Elaine. So the methodologies, we say, are incomparable. And to make that point, may I ask, please, that we look in the supplementary bundle at page 199. This is the this is the report of Professor Jones, and the graph in the middle of the page is the graph that Professor Jones has created using the occupational exposures from the data set in Hodgson and Darnton and then extrapolating down. It is a logarithmic scale, so that there is a increase in order of magnitude between each of the units on both the x and the y axis. We can see, just by looking at, so you are directed to the red dotted line, you can see that when you look at it at the lowest level, so put by, in the corner it's 0.001 on both axes. If it was proportional, as opposed to being linear, they would both say 0.001. And that's because the data that feeds into the graph is the Hodgson and Darnton data. It's not the reasonably scientific compromise that risk is proportionate to dose. And if we look back at the previous page, we can see that the formula that's used by Hodgson and Darnton, which is set out by Mr. Jones, and if one looks down the page, you can see the table, and above the table he says the coefficients for pleural mesothelioma in chrysotile exposed cohorts are set out as below: best estimate slope, high slope, low slope, and it's those best estimate, high slope, low slope which are the red, the blue, and the green line over the page. So we have a formula which is adopted for the graph, which is incomparable to the approach in method 1. I think if there was any perhaps slight, well, perhaps it was my confusion, perhaps, but just to ensure that it wasn't just my confusion, when my learned friend refers to linear, that is not the same thing as saying it's proportionate. And the thing about method 1 is it's proportional. My lord, can I move to a different point now, if I may? And ladies, my apologies. The different point is this. It's the attempt to rely on the literature in and of itself. Any findings for the court below, a fortiori, this court must be grounded in the expert evidence that the court below heard. And in the authorities bundle, there is a case of DNA fact-finding research literature, which is at tab 6. And if I could...
I'm not sure this was a case we were taken to in anybody's submissions.
Not in the earlier submissions, no, my lord.
It's a point of reply.
it's a point of reply because...
What is the point you're replying to?
The point I'm replying to is that you cannot... I understood my learned friend to rely on Hodgson and Darnton as providing an independent basis for this court to prefer method 2. And I'm saying that that is not...
It's simply part of the material that the experts relied on at trial.
Yes.
I mean, that's the relevance of all of these papers. They're papers that all of the experts considered, dealt with in their joint statement, dealt with in their reports, were cross-examined about.
Yes, well, my lord, if that's the view,
well,
my lords and my ladies,
that's not a question of the view, that's the fact. So I'm always a bit nervous about going to cases we've not looked at in reply, unless what's the point that comes from the authority at 6?
Without wishing to...
what's the point you're replying to then?
Yeah, the point I'm replying to is that the court cannot use the literature as an independent basis to make any judgments in this case.
And do you say that's what the judge did?
No, I don't, but I say that's...
Fine, so it can't be a point of appeal then. If the judge didn't do it, we don't, and so you're not criticising the judge, then we don't need to worry about it, do we?
No, and as I say, my lord, if it's not a point that concerns you, then I won't pursue the point. It's just that I had understood, and perhaps it's my fault, I had understood my learned friend to suggest that by reference and looking directly at Hodgson and Darnton, that provided independent support for method 2, rather than looking at what the experts had said about Hodgson and Darnton. And it's that I'm replying to. It's
right.
It's a short point, my lord, and I hear what you say, and I will.
Let's look at it then.
It's a paragraph page 111 of the first literature bundle behind tab 6.
Yes.
So it's paragraphs 84 to 86.
Yeah.
And my lords, my lady, the context in which I raise this is because Professor Jones, you'll remember in the course of his evidence, was explicit that he was not putting forward any methodology in preference to another, and agreed he's not an epidemiologist, he doesn't hold statistical qualifications. And it's in that context that I raise this particular point, because obviously if the court below, or this court...
So 84 to 86
yes.
contains some fairly sensible, so it appeared to me,
yes.
Observations about the use of research literature.
Yes.
So what's the submission you make on the basis of 84 to 86 that you've taken us to?
The submission that I make, my lords, and I apologise if I wasn't clear.
No, I'd just like to know
Yes,
the submission.
yes.
We've gone to the case.
Yes.
We've gone to these paragraphs.
The submission in, as I understood my learned friend to do, when he says the court can look at Hodgson and Darnton itself and come to a conclusion by looking at the paper alone, that is not open to the court below or indeed to this court.
Just so I understand how far this point goes.
Yes.
Professor Jones's conclusions and
Yes.
his worked examples were based on his interpretation and application of
Yes.
H&D.
And I've no.
Yes.
I'm not trying to go behind that and say that he can't put for those.
And the judge found that highly persuasive. That's what he said in terms
Yes.
of paragraph 112.
Yes.
Yeah. Okay.
I hope that was not making more than it was necessary of that particular point. But if I can move away from that now to direct my lords and my lady to the supplementary bundle and to the evidential context in which I say this point fits. So it's at page 286 of the supplementary bundle first. And the top section by A. Where Professor Jones says he doesn't have any statistical professional qualifications. He has published papers in epidemiology, but he has no epidemiological professional qualifications. And I raise this point, obviously, to draw a distinction. It's what the judge effectively found when he said the Professor Jones and Professor Norrie were complementary. One can tell me about statistical reliability. The other can tell me about toxicology and how that fits into this case. Page 319 of the supplementary bundle. Dr. Moore-Gillen, again, accepts that he's no formal qualifications in epidemiology. And then by C, he says he defers to epidemiologists on matters of statistical reliability of the epidemiological studies. So he himself says, my role, as I define it, is not to look at the statistical reliability of epidemiological studies, but to use the information and put them into the models. I used the words plug the information in, and he said I don't do it uncritically, but he agreed. He puts the information in to look at the outputs. And that's obviously important in the context of this appeal, because this appeal is fundamentally about the statistical reliability of Hodgson and Darnton on ground 1 and of the use of 0.5 in 1,000 as Elaine's counterfactual risk. My lords, my lady, there much was made of the fact that it was said Professor Norrie made mistakes. I'm not going to touch on that point because my learned leader is going to deal with it, but I just want to demonstrate that mistakes were common across all of the experts who gave evidence to the court. In respect of Dr. Moore-Gillen, I've already taken you to the section, so I won't take it to you again. The section where he conceded that he had wrongly interpreted Peto and Rake, so that he had put it as a rule of a third that a third of mesotheliomas in women were idiopathic. He accepted rightly that that is not a proposition which could be drawn from the Peto and Rake paper. But that was not his only mistake.
That was Professor Jones talking about?
No, that's Dr. Moore-Gillen. Dr. Moore-Gillen. Dr. Moore-Gillen, if we turn to 247, this is his report, and it's the first paragraph of the conclusion that I wanted to draw your attention to. It said in the second sentence, Petto and colleagues suggest that in the UK each year there are about 100 cases of mesothelioma in women which are entirely unrelated to asbestos exposure. And further cases. But it's the first part of the sentence which is clearly wrong. That is not what Petto and their colleagues say. And if you will just indulge me for a moment, I can see where his mistake has occurred, because if we look at 341, which is the British Journal of Cancer paper by Petto and Rake, towards the bottom of the right-hand column, there is a sentence which begins, "This would imply." What the authors of the paper say is, "This would imply that at least 30% of female cases, of the order of 100 per year," so that's the same number that Dr. Morgillan referred to, 100 a year, are caused either by environmental asbestos exposure or by occasional and ambient exposure in occupational settings that we have classified as low risk. So he's just misread that part of the sentence to say that is idiopathic, when what the authors say is this is the part that relates to ambient exposure or unrecognised.
Sorry, was that actually put to Dr. McGill? I'm not clear it was. I don't think my friend's right.
Well, it's self-evident from the paper, I would suggest, but it's a matter for my lords and my lady. The point is simply this: there were mistakes made by all experts in this case, and it's wrong to suggest that Professor Norrie was unique in that way. Professor Jones, in his original report, suggested that the correct legal test was doubling the risk, which was obviously wrong because Sienkiewicz had decided that that was the incorrect legal test. So to suggest that Professor Jones didn't make any mistakes is unfair and unjustified, and it amounts, I would submit, to a unjustified character assassination of Professor Norrie. There's nothing in the judgment to support a finding that he was mercurial, for example. My lords, my lady, if you will bear with me, can I ask you to look at the supplemental information provided by the respondents from Hodgson and Darnton? So this is in the supplementary bundle now at starting at page 326A.
It's all in the supplementary bundle. I mean, all the references. I've never known an appeal where it's the supplementary bundle that matters. Page which?
It starts at page 326A. But can I invite my lords and my lady to look at table 11, which starts at 330G, but to turn the page, please, to 330H.
Yeah.
Table 11 is where Hodgson and Darnton do undertake an extrapolation exercise, and the part that I wanted to draw your attention to is in the table on page 330H, next to the words. It's the first sentence underneath the title and the last part. Recognising the quantitative uncertainties are very considerable.
And that was something recognised by the judge.
Well, yes, he said he interpreted Professor Norrie's evidence as that this data could be used with significant caution, but as you know, my lady, we take issue with that. At 330E.
So before you just move on,
yes.
What do we take from that? Because that doesn't stand alone, that phrase. Unlike it with any other of the above sections, the report's table says the absolute risk is low, but quantitative uncertainties are very considerable. What, within the boundary of this section, or quantitative uncertainties in relation to this and the remainder of the report?
I think that is explained in the section I'm just about to take you to, which is 330E, and it's the part entitled Quantified Risk Assessment. And it's the first, if I could just invite my lord and my lady to read the two paragraphs on page 330E under quantified risk assessment. My lords, my lady, the point that I'm making is these are the exact issues which Professor Norrie was raising, and he gave the direct evidence on statistical reliability, and it was his evidence that it was unsafe to rely on this data. And indeed, you looked at or my learned friend took you to the Watch paper, and you will see that concern was widely shared by the members of the Watch committee. I won't take my lords and my lady to that paper again, but that is a point which, again, I would submit supports the concerns and opinion expressed by Professor Norrie.
I didn't read what we were shown from the Watch paper as indicating significant concerns over reliability.
Perhaps it is worth going back to that then, because I think there is so it's at page 336 of the bundle. Sorry, it's page 336.
Yeah.
Bottom paragraph. It's the last part after the semicolon, beginning with the word however. And in particular, I would say strong language, that the suggestion that presenting such estimates in numerical form or using them for decision making in a way that might be taken by others to imply confidence in their numerical accuracy. That's the part that I emphasise, which I say chimes with Professor Norrie's evidence. My lords, my lady, may I turn to a different issue? and that is one which relates to method 3, and my learned friend raised this in a number of different ways. One thing that he said was that there was an absolute risk of 1 in 248 million. I don't agree with that. There's no evidence before the court in respect of that. And in any event, he is talking about an absolute risk. Elaine did, as a matter of fact, suffer from mesothelioma. No matter what the risk of it was occurring, she did. And so the only question is, to what extent has the tortious exposure increased the risk that exists in that counterfactual situation where there is no tortious exposure?
Well, I don't think that's an accurate representation of the evidence.
I'm well aware of that. Well, sorry, it's not an accurate representation of the test.
I'm sorry.
That's fine. I understand the submission.
I apologise, my lord.
No, it's fine. I mean, I understand what you were getting at. I was just clicking through in my head what the test was. But
the test, material increase in risk.
Your point is she suffered mesothelioma. The question is whether the tortious exposure materially increased her risk.
Yes. Yes, I'm sorry. I expressed myself, no doubt, in an incorrect way, and I apologise for that. To ask what the absolute risk is, we would say is wrong in law for the reasons that we have set out in the supplementary skeleton argument. It is not logical because if you ask and only consider the question of absolute risk, you're asking what the risk of something occurring for a person where that risk has already manifested. It does not assist with attribution. The only way you can assist with attribution is to see what the starting point is and how that has moved by reference to the tortious exposure. And to take method 3 to its extreme, and indeed this is what Dr. Morgillan in his Evans suggested. He suggested drew an analogy with somebody getting struck by lightning, and said, well, nobody would consider that a risk which you ought to worry about. And that isn't the right way to frame the question. The right way to frame the question is somebody who has been struck by lightning. What things played into that risk? Were they wearing a helmet like Kaiser Wilhelm, or were they standing under a tree? The focus on it being a small risk to start with also creates a real danger, because if, and I don't, as I say, I don't accept or agree with the figure of 1 in 248 million, but if that's doubled to 2 in 488 million, then that we know must be sufficient. It's a 100% increase in risk. We know that must be sufficient to prove the case on causation, because the Supreme Court in Sienkiewicz say that you don't need to prove as much as doubling the risk. You only have to prove a material increase in risk, which they identified to be more than de minimis. Method 3, we also say, is unsafe because it relies on extrapolation. And as my lady pointed out, the medical profession is not uniform, and to suggest that it is an objective measure is not correct. my lords, my lady, may I again move on to a different point? My Lord Zacaroli asked what the difference would be by changing the denominator in the calculation because of Professor Jones's concession in his oral evidence that 0.5 in 1,000 was rather too high. It is not just the denominator where there was a concession, but also the numerator. And so at page 284 of the bundle, this is the section in examination of chief of Professor Jones, where he says, having been asked about Hodgson and Darnton and the difficulties with it, he says, it's for the court to make sense of that, including how you treat the very large uncertainty in Hodgson and Darnton, which is something you do not necessarily always have cause to look at. So there is a temptation to produce a central value, but you simply cannot do that. So, and that's he confirmed in cross-examination. I've already taken you to the section, so I won't take you again. It's not just therefore the denominator, but also the numerator where there is uncertainty. And if we look at the learned judge's judgment at paragraph 59, it's the table and it's Mr. Steer's figures, and it's the best estimate, which is the 0.002, but then also the lowest arguable and the highest arguable. We have several orders of magnitude of difference between those figures. And that uncertainty means that the range that you get is much greater. And it's when you take the highest arguable, 0.22, and the 0.1 figure that Professor Jones said in his oral evidence, he gave that range between 0.1 and 0.5 in 1,000. If you take both of those figures, use those as your numerator and denominator, that's where it becomes a material increase in the risk, using the method 2 methodology.
What's the
2.2. 2.2%. And that's why, my lords, my lady, was the submission that I made during the course of my submissions was, it's an impractical way. It doesn't provide an answer to the court. The evidence is you can't use a single figure, but the range extends from a material increase in risk to a de minimis risk. So it tells us absolutely nothing. It doesn't give us an answer. If I may move on to a different point, it was suggested by my learned friend that method 2 is more sophisticated. And that, in my submission, makes it not better but worse, because the sophistication is the complexity from relying on uncertain data or uncertain propositions. Method 1 is much more simple, but that is highly preferable in a situation where there is large uncertainty, as there is in this case, it is better to accept to adopt a widely accepted and scientifically reasonable compromise, to use the words of Hodgson and Darnton, even though it's not a perfect system. And method 1 is not a perfect system. No system can be created which is perfect because of the uncertainty that exists. But it is, to use the words of Lord Phillips in Sienkiewicz, it's faute de mieux, for want of a better alternative. Method 2 is built on unreliable foundations and gives an unwarranted false sense of accuracy. It is also a system which is skewed in the defendant's favour, because they get to take advantage of one uncertainty whilst ignoring others which may go against them. Why should they get the benefit of the doubt? That's not a fair or just resolution. And indeed, there is a recent analogy. I hope this is not overly dramatic, but there is a recent example from history of a so-called sophisticated system which gave rise to the biggest miscarriage of justice in English history, the Horizon computer system, which was relied on and which led to the wrongful conviction. That I don't wish to be overly dramatic.
With that analogy is that the system wasn't very good, but that was completely covered up by lying and incompetent human beings.
Yes.
For years.
Yes.
So I understand the analogy, but that's the real scandal.
Yes, I accept that.
Of the post office case.
I accept that.
I'm not saying the Horizon system was marvellous. It plainly wasn't. But it was the fact that it wasn't marvellous was just covered up.
I accept that entirely, my lord. And the only point I'm wishing to make, and I don't want it to become more of a point than it deserves to be, is that an unreliable system which suggests it is sophisticated gives a false sense of accuracy. And that's exactly a point that Professor Norrie made in his oral evidence when he talked about people understanding a simpler system, the risk of tossing a coin. He said there's a psychological element to it. And that's what he meant in my submission, that you don't have this false sense of this is the right answer because this is what this complex system, albeit a complex system built on sand foundations, says. Can I deal briefly with the cases of Bannister and Kerr? I don't want to say very much about them at all. Bannister, the comments from the learned Deputy High Court judge were obiter because he had decided there was no exposure to asbestos, and he adopted method 3, as I understand the case to be. And my lords, my lady, you already have my submissions on why method 3 is an inappropriate methodology. He, of course, didn't have the benefit of epidemiological evidence or an expert review of the literature to test against the propositions put forward by the experts in that case. In the respect of Kerr, this is a case of peritoneal mesothelioma, not pleural mesothelioma, as Elaine suffered from. It is a different condition, and on the evidence before the Scottish court, it was found that there is a much less strong link to asbestos for that condition. And that's at paragraph 78 of the judgment. But I don't ask you to look at that now. But also, that case was cast in a very different light, as I believe my learned friend rightly acknowledged, putting it more akin to a Wiltshire situation, if I can put it in that way, than a Fairchild situation, because there was doubt raised as to whether asbestos was implicated because there was this less strong link between peritoneal mesothelioma and asbestos. It's a case decided on wholly different issues. It's not helpful to the court on the resolution of these issues. The case which is clearly very helpful and authoritative is Sinkowitz. And if I can invite my lords and my lady to page 498 of the authorities bundle, 489, I beg your pardon. And I'd simply invite my lords and my lady to read paragraph 59 and 60. And the submission that I make is that there is an obvious analogy between the facts in Mrs. Costello's case and the case of Elaine Johnstone. And you'll see, my lords and my lady, that it's the approach taken was to look at the risk in her lifetime and the risk from the tortious exposure to compare the two. So that exactly what's being put forward by the claimant, the appellant in this case. Can I turn now to the role that epidemiology plays in this case? My learned friend said that the appellant was seeking to attack epidemiology, or it was a dirty word, I think was his phrase. And that's not, I want to be absolutely clear, that is not the appellant's position. We accept, as we must do, that epidemiology provides critical research for advance in many fields of study. It is just that mesothelioma poses a particular and unusual problem, and Lord Phillips in Sinkowitz identified that. And if, my lords and my lady, I could ask you to turn to 498 of the authorities bundle.
Yeah.
And Lord Phillips, under the heading, "Can the doubles the risk test be applied in mesothelioma cases?" He poses a conundrum, and he asks the question, which he says is the conundrum: why, if it was possible to equate increasing exposure to increasing risk, i.e. method 1, could one not postulate that on the balance of probabilities, where one employer had caused over 50% of a victim's exposure, that employer had caused, on the balance of probabilities, the victim's mesothelioma? That's the conundrum which he refers to, and the answer he gives 3 answers. The first is at 95 to 97, which is the reference to the yellow taxi, blue taxi. It's an improper use of statistics. It's an improper use of epidemiology, which my learned friend has taken you to, so I won't ask you to look at that again. The second answer he gives is contained at 98 to 102, and this, in essence, can be labelled as doubts about the reliability of the epidemiology. So, at the very, I would invite my lords and lady to read that, perhaps not now, but you will note that the last sentence of paragraph 99, one of the doubts that Lord Phillips raises is the doubt about extrapolation to cover victims who've had very light exposure.
But that's not in relation to Hodgson and Johnstone, because that wasn't in the case.
No, I accept that. I accept that, my lord. It's a more general consideration of epidemiology. Yeah. And if one looks at 101, he makes this point: most significant inhibition on the use of epidemiological evidence to determine causation in case of mesothelioma is uncertainty as to the adequacy of the data. The data is relied on as establishing that the risk of contracting mesothelioma is proportional to exposure to asbestos. That's the epidemiological underpinning of method 1 that I rely on, and that's what he identifies as what the epidemiological evidence goes towards. His third reason for answering the conundrum comes at paragraph 104.
So I just wonder whether a friend might just read the end of that page he's on, because it's about proportionality.
The end of page 499.
499, yeah.
The last sentence?
The last 4 lines.
The last 4 lines, okay. The data is relied on as establishing that the risk of contracting mesothelioma is proportional to exposure to asbestos dust. It used to be thought that mesothelioma was probably triggered by a single asbestos fibre, and that the cause of the disease could be attributed exclusively to that one fibre. Were that the case, it would be reasonable to postulate that the risk of contracting the disease was proportional to exposure. And then it goes on. That's the point you wanted? I understand the point that my learned friend makes, but that doesn't detract from the earlier point that epidemiological evidence goes to showing that the data is relied on as establishing that the risk of contracting mesothelioma is proportional to exposure to asbestos dust. Sorry, the third answer that Lord Phillips gave was at paragraph 104, what he says here is the possibility that mesothelioma may be caused by the result of the cumulative effect of exposure to asbestos dust provides a justification, even if it was not for that reason, for restricting the Fairchild-Baker rule to cases where the same agent or agent acting in the same causative way has caused the disease, so the possibility will not exist in respect of risible causes that did not exist in the same causal way. So I understand his third reason to be the fact that you have cumulative risk from greater doses means that this isn't a Wilshire type situation. It would be otherwise, and there wouldn't be the justification for the distinction between Wilshire and Fairchild.
So the fact you have cumulative risk from
repeated exposure or more exposure. As Lord Phillips himself says, the result of the cumulative effect of exposure to asbestos. my lords, my lady, we say that the way that Lord Phillips has dealt with epidemiology and think of it is exactly the way that the appellant seeks to rely on it in this case. We're not attacking it as such, we're just recognising that it's a very difficult situation where there are enormous uncertainties in the case.
The conundrum that he's dealing with, though, of course, doesn't arise here.
No.
Because the conundrum is the terrible problem in these cases of people who were employed by a number of, in the old days, shipbuilders and exposed to asbestos, 5 years here, 6 years here, 2 months there, that sort of stuff. That's the conundrum he's posing.
The conundrum, as he puts it, is if you can say 50% of exposure is in one place, why can't you say that proves it on the balance of probabilities? That could apply just as equally to a low exposure case. So if you take, for example, a case where there is an exposure, but it's less than 50% of the found environmental exposure, then the conundrum would still apply in the same way. My lords, my lady, there's it was a short point. My learned friend suggested that I hadn't put to Professor Jones in the trial below that he should prefer method 1. I didn't need to because he'd accepted in cross-examination that he wasn't putting forward any methodology as one which the court should accept. So it was a blank canvas. He'd made the concession I needed.
So my point was that it was never put to Professor Norrie that method 1 was the right one.
Well, that I might find a very surprising proposition because Professor Norrie's report and calculations were based upon method 1.
I think there's a slight disjunct between what now everybody is calling method 1 and method 2 and how it was actually dealt with at the trial. Certainly the final submissions talk about method 1 and method 2. But anyway, you say that Professor Norrie's calculations or evidence was based on method 1.
Yes.
Although he doesn't call it that.
No, I accept that.
Nobody did.
No, and to give you, I'm not.
We've got to decide the battle of the methods.
Yes.
Which has emerged blushing into the spotlight partway through this vigorously contested case, which I'm sure we will. But there are quite a lot of pitfalls that we have to avoid.
Yes.
Anyway, you say his basically say you didn't need to put to him. It was obvious.
It was obvious. It was his evidence that I based the case on. And I accept the point that method 1, the terminology, came later. It was, I'm not sure if it was a mixture of my methodology or Mr. Williams. I'm not sure if I should take the full blame for it or not. But it's nothing more than a label which has arisen in the course of the trial.
Well, it's rather more than that now on this appeal.
Yes.
Yeah.
Again, a short point. It was suggested by my learned friend that going into the trial, the ratio that was accepted between the different types of asbestos was 1 to 100 to 500. That's not correct because Professor Norrie in the joint statement was clear that that wasn't what he was saying. So it's at page 228 of the bundle. And at paragraph 6.3, and it's the part after B.
Sorry, can I just have those pages again, please?
My apologies.
No, not at all.
It's page 228.
Right.
In the final 3 lines after the letter B, he makes the point it's much less clear what the actual gradient of risk is across these fibre types for non-occupational exposures. And those words, occupational and non-occupational exposures, have a particular meaning. The section that my learned friend took you to, if the joint statement had the words occupational exposures. And that's because in Hodgson and Darnton, they use occupational exposures as an explanation for the very high, the cohort where there was a very high level of exposure to asbestos. So it was a contested issue throughout that as to the potency of chrysotile. And you've heard, you have the points as to how the evidence came out at trial, that it was a matter of genuine debate, is what Professor Jones says, and Professor Norrie saying the evidence shows that it's basically an unknown. Again, I would make the point that on that question of potency, we're talking ultimately about statistical reliability of epidemiology. Which one of the experts is better to answer, in a better position to answer than the others.
Well, this proposition comes from H&D.
The 1 to 100 to 500, yes.
But I read him, I mean, it may be what
Yes.
you mean by occupational exposure, but in determining what the exposure was while working at Fawcett's garage, that is occupational exposure, isn't it?
Yes, I accept that, but it's confusing because the way that it's put in the papers is that it's unrecognised occupational exposure in occupations where it's associated with a lower dose. And there's a distinction between, if you remember the Peto and Rake 1 in 1,000, there was the recognised occupational exposure, and then there was there was 3 other factors which went into the other part, and that's the occupational exposure was taken, as I say, as I understand it, for a proxy for the high exposure. That's certainly how I read Professor Norrie's evidence, and that's the only logical way to distinguish how he's differentiated between occupational exposure and non-occupational exposure.
The problem is with non-occupational exposure that you, the
Yeah.
problem with exposure which you didn't realise you had was
Yeah.
ambient.
Yeah.
You wouldn't know which fibres were involved. Couldn't know.
Yes.
But you do know when it's occupational because you know what the occupation was doing, so you can find out what asbestos it was using.
Yes, well, and then there's a difference, isn't there, between, say, Elaine's situation and somebody else. So somebody who has exposure whilst they're at work, but not themselves working with asbestos, may be in a much less good position to say what type of asbestos it was.
But we know in this case.
We do know in this
It
case.
was chrysotile.
Yes.
Yes. Yeah. Thank you.
My lords, my lady, the next point, and I've only got a couple more. I'm very conscious that I don't want to overrun.
Well, as I say, we haven't sought to restrict you. I would point out that the appellant had all of yesterday but an hour, and you've now been going for more than an hour in reply.
Yes, my lord.
But carry on.
The point that I wanted to deal with is how it was raised, how does the appellant deal with idiopathic risk? And the answer to that is in the same way that Lord Phillips in Sienkiewicz says that it should be dealt with. And that is at paragraph 19 of Sienkiewicz, which is at page 475.
Do you want us to look at it?
Yes, my apologies. At the very bottom of 475, Lord Phillips, he's describing in this section what's known about mesothelioma. He says, and by Roman numeral 1, mesothelioma is always or almost always caused by the inhalation of asbestos fibres. And then 2, a significant proportion of those who contract mesothelioma have no record of occupational exposure to asbestos. The likelihood is that in their case, the disease results from the inhalation of asbestos dust that is in the environment. There is, however, the possibility that some cases of mesothelioma are idiopathic, attributable to an unknown cause other than asbestos. Mr. Stuart Smith QC, as he then was for grief, submitted that the PETO report, the same PETO and rake report that we're concerned with, indicates that this is more than a possibility, but I do not read it so. There was a disagreement between Lord Phillips and Lord Justice Stuart Smith, as he now is, as to how to interpret the PETO and rake paper. He goes on to say, though, I do not, however, think that it matters whether some cases of the disease are idiopathic. The more fibres that are inhaled, the greater the risk of contracting mesothelioma. That's the correct position to adopt, and the position that the appellant adopts in this case. The evidence that was before the court below was that idiopathic mesothelioma is this is Professor Jones's language, is a very nebulous thing. One can only guess as to what it is. You can't factor in to any methodology an issue which you can only guess at. If it's 0, it doesn't call to be taken into account at all. If it's 33% or some other percentage, it ought to be taken into account in a different way, but you simply cannot do it where you do not know whether it even exists as an issue and to what extent it exists. My lords, my lady, thank you for allowing me that time. I will come over to anything.
May it please my lords and my lady, I'm going to take you through about 4 points, I hope, possibly 5, I think 4, by way of bringing us home. I hope to do so.
I'll number them.
I knew I should not have been foolish enough to open my mouth and offer a number in my lord's presence.
1.
Let me see if I can stick to 4. Worse, it could be counting down towards a particular time, but we'll see if we need that. My lord, I hope to be done in 20 minutes maximum. The first, if I can slip this in as not one of my ones, is simply to, there's an advocate's trick for my lord, is to endorse what my learned junior has said about epidemiology. Now, my learned friend Mr. Platt, with his background in politics, has adopted a very clever debating technique and has mischaracterised in his submissions our position. We have never said epidemiology is a dirty word. We have never said it isn't necessary. We have never disproved of it. All the things that were thrown away comments by Mr. Platt. The issue is how it is used. And that is fundamental to understanding how the court should and can approach material increase in risk. Can it simply accept, and again I'm slightly eliding what my learned friend Mr. Swoboda said earlier, can it simply look at statistics, or must it look at statistics, papers, with the benefit of the opinion of an expert epidemiologist as to whether those papers can be extrapolated or developed, and then apply them to a factual situation? Of course it's the latter. One needs to do all those things. And again, we simply remind the court that you heard earlier, you looked yesterday at the extracts from Phipson, it doesn't matter which edition it is, it says the same in both, and from Lord Phillips and Sienkiewicz. Epidemiology alone is not an answer. So if I can slip that in as the first non-point, let me come to the first main point, which is to address what my Lady Justice Nicola Davies asked during the course of submissions about, has anything changed since Sienkiewicz? In terms of the law? No. In terms of some aspects of medicine and science, yes, in the sense that we understand a little bit more about the cellular processes once a cancer, such as mesothelioma, has begun, how it multiplies, how it might be slowed or stopped. That's common, of course, across all cancers, thank heavens, due to research in the last decade or more. But do we know anything more, scientific, medical, or technical, about the material issues in this case? No, we don't. We have no better understanding than was the position when Sienkiewicz was heard. But if I take one step back, the first instance decision in Sienkiewicz was 2008, and it's important not to lose sight of dates. Mr. Platt tells us Hodgson Darnton was new. Hodgson and Darnton is published in 2000. It's there, it's available. It was available 8 years before the first instance trial in Sienkiewicz. It's not new. It could not possibly be described as being new. Slightly off tangent, it's no more than a meta, I dare say, it's no more is very unkind because it's a distinguished paper, as Professor Jones recognised in conducting a meta-analysis and drawing together other papers, but all the other papers it drew together preceded it. So all the material from which Hodgson and Darnton was drawn was available before 2000. And therefore it is no surprise, to answer my lady's question, that the approach following Sienkiewicz has been in use since it was decided. Hodgson and Darnton hasn't driven the cart and horses through the approach that Lord Phillips commended. What has changed, and it is important that my lady has, forgive me, and my lords, of course, have this perspective, is, I hope I remember saying, in my submissions, the basket of cases that insurers now have to deal with. And of course, my lady and my lords know that in this sort of litigation, this is not an individual defendant on the high street. There are insurers who stand behind and defend these cases across and take a strategic view across. But the basket of cases insurers now face have many more low-dose cases as the older and bigger exposure cases recede into history. The laggers were lagging in the shipyards, the joiners were undertaking carpentry 40, 50, 60, 70 sometimes years ago. So those big cases have gone, the cases of clear substantial industrial exposure. And in many cases, therefore, that is why, often indeed by engaging my learned friend, or either of my learned friends to fight cases at trial, there are two approaches. One is to try to dispute the historical recollection of whether there was asbestos at all, because low-dose cases inevitably are short exposure in schools, the sort of thing Mr. Platt has referred you to in Kerr. Somebody using, I went to school in Scotland, Bunsen, we call them, but Bunsen burners. They're asbestos-related, asbestos-containing mats. Were they really asbestos at all? The Lloyds Bank case, was there in fact asbestos in the room? The Bannister case, was he in fact exposed to asbestos dust? So these low-dose cases permit of attack on the facts, but recently also, my lady asks what's changed, and this is what's changed. A change in tack to try to change the court's approach to material increasing risk, which is exactly what we see in this case. Trying to persuade judges to adopt models for material increase which favour the defendants, by seeking to focus, as my learned junior has, I hope, explained, and I'm sure the court has in mind, only on one aspect of the guilty exposure, that is fibre type, that's chrysotile, so as to skew the balance, to skew the equation, so that there is less potency, it is said, to the guilty exposure as against the continuing greater potency of the background. And that is precisely what happens in this case. It is also, as my lady will have appreciated as the arguments have developed, why the defendant tries to push its method 3, because that is a means by which the defendants can unshackle themselves from the difficulty of proving a material, disproving a material increase in risk. It's unsustainable, it's legally unsustainable, because we say...
Sorry,
It unshackles them from what?
Sorry. Let me try that sentence again. I think I said more than I should have done in it. The defendant's suggestion of method 3, as well as Junior's explained, is, as Mr. Platt accepts, an absolute measure of risk. It's not a comparison. Therefore, of course, legally falls foul of Lord Phillips' formulation in Sienkiewicz that what the court's looking for is a material increase. And as Mr. Swoboda has illustrated, a material increase can still be a very small number, but a material increase from another very small number. But that's the test. What Mr. Platt urges on the court, and indeed tried to do in the case of Bannister, and achieved it only obiter, is to say instead, no, we don't look at a material increase at all. We'll sidestep Sienkiewicz, and instead we'll look at, was the guilty dose material? And Mr. Platt's solution in method 3 is to say, well, what is material? What would a doctor think? And my lady, Lady Justice Nicola Davies, has picked up on one of the obvious problems with that, which is that, first of all, it all depends on the quality of the medical expert in any given case. What it also allows defendants to do, or would allow defendants to do were it to be adopted, is simply to rustle up a dispute. I say simply rustle up, forgive me, that's too language, for there to be an argument where a medical expert could be wheeled out or produced to give evidence to say, frankly, any percentage didn't seem to them to be material. And you see a hint of that in the underlying material, in this case before you now. You see Dr. Moore-Gillen telling you that, well, if you compared it with the risk of being struck by lightning or the risk of crossing a road, he wouldn't find that troubling. Now, that doesn't matter one jot, we say, when one looks at Lord Phillips and Sienkiewicz. Whether Dr. Moore-Gillen is troubled by a small percentage risk as a medical professional is neither here nor there. So method 3 fails practically, it fails forensically, because it opens the floodgates to enormous dispute which shouldn't arise on the law as it stands. And it fails because it is contrary to the principle established in Sienkiewicz. So, forgive me for taking slightly longer than I intended. You may hear that again, but that's what's changed. That's the context in which my lords and my lady have this case. That was my first substantive point. The second one is very short indeed. My learned friend again over-caricatures rather than characterises our case as being an attempt to refight this litigation and have Professor Norrie preferred over Professor Jones. No, we say. The court will have seen that the judge preferred the thrust of Professor Jones. I won't take you back to paragraph 110 of the... Sorry, Norrie. I've got my Jones and Norries mixed up. Pause for one moment and we'll try again. Professor Norrie, I will in no circumstances take you back to paragraph 110 of the judgment, which I'm sure must be the most frequently referred one during this case. But what one has to do in my submission is to look at paragraph 110 and say, what on earth does this mean, other than the judge believed that he was preferring what Professor Norrie said about the reliability of the epidemiology, the reliability of extrapolating from Hodgson and Darnton. This sentence in the judgment cannot possibly be read any other way. In terms of the thrust of Professor Norrie's evidence, the judge didn't adopt any other aspects of it. He didn't adopt, for instance, Professor Norrie's figures. What he does in this paragraph is focus on the model and the confidence of extrapolating from that model the Hodgson and Darnton figures. So it can only mean, properly read, this paragraph of the judgment can only mean, properly read, the judge believed he was endorsing or accepting what Professor Norrie said. And I come right back to where we began yesterday morning, that is a mistake on the judge's part because Professor Norrie did not say this.
Yes, so, and I understand that. So you accept it's on the premise of that reading of the paragraph. I mean, you say it can't be read any other way.
I do.
But if it could, then he's not saying he prefers Professor Norrie. He accepts the thrust of his evidence, and then he goes on to say, in any event. There's an in any event, and then the following paragraph on the other hand. So it seems to be an attempt on the face of it to identify where the evidence, as far as the judge is concerned, is complementary.
Precisely what he's trying to do is to tie together, as he said he was going to do in the first sentence of paragraph 109, not to discard the evidence of either expert.
Yeah. So anyway, your submission is that you can only read 110 as saying he preferred Professor Norrie's evidence, and on that premise, he was wrong when he said that was Professor Norrie's evidence.
Yes. But forgive me, my lord, it's even clearer than that. The thrust of Professor Norrie's, which I interpret to be the exercise of significant caution when seeking to extrapolate down.
Yeah.
He's telling the court, and he's telling us as readers of this judgment, what it is he's done and what he believes Professor Norrie meant.
Yeah.
And in that, he's simply wrong.
Well, we understand that.
My lord has the point.
But that, as I say, that's based on the earlier premise.
Yes.
Yeah.
That was my short second point. My third is this. Second point, forgive me, just to close that down, we're not seeking to relitigate. We're seeking to construe and understand the judge's judgment and the reasons he gives. And what he says is the reason he gave for allowing extrapolation from Hodgson and Darnton was that he thought Professor Norrie was okay with that, or endorsed it, or accepted it. Well, that was what he thought. He interpreted Professor Norrie as meaning that one could safely, with some caution, extrapolate. And we say that's simply not the case. So that closes off, if I may, the second point. The third point is this, and it's a combination. It plays back into that ground one point, but is also what I may characterise my learned friend as doing, which I call Norrie bashing. There's a lot in the skeleton argument for the respondents and in my learned friend's submissions, oral submissions, which amounts to a personal effectively a personal attack on Professor Norrie for having changed his mind, for being mercurial, a word the judge didn't use, but the defendants, respondents to this appeal, labelled him with. But again, my lord, we emphasise one must see what Mr. Platt attempts to suggest as an unreliability on the part of Professor Norrie by looking again back at paragraph 110. The judge did not say he discounted Professor Norrie's views at all. He interpreted them, and he interpreted them wrongly. The judge identified at paragraph 109 that the expert's expertise was complementary, he believed, and he asserted that it helped him come to his conclusions. The judge recognised earlier at paragraph 28 of his judgment that Norrie was the statistician or epidemiologist, and Jones as a toxicologist. And in the context of what I've called Norrie bashing, Professor Norrie, of course, doesn't stand alone. Now, my learned friend, my learned junior, took you to the Watch paper, and I'm not going to invite my lord and my lady to look back at it now. I'm simply going to read a little bit more of it to you to show you that Professor Norrie's views, in fact, align entirely with those of the Watch group, which is part of the HSE, which includes Hodgson and Darnton and a number of other eminent experts. And again, for my lord and my lady's notice, my Lord Justice Coulson's point, supplementary bundle is in fact the core bundle, really. It's tab 27 and it's page 336, simply for your note. I don't invite you to turn to it. But what's said there is Watch, that is, on behalf of the entire body, the HSE-sponsored and endorsed organisation, considers that all of these uncertainties impose limitations on the reliability of risk estimates produced by the H&D model, particularly when it is extrapolated to exposure situations and to populations beyond those covered by observed data. Now, the observed data that Hodgson and Darnton were dwelling on, of course, was high exposure, serious industrial, if I may use that word, industrial type asbestos use. Hence, Watch confirms the statement in its 2008 conclusion, so we're 3 years on, this paper is 2011. Risk estimates derived by extrapolation of the model should not be taken to be reliable absolute risk values. The limitations on the reliability of those estimates derived from using the H&D model becomes more pronounced the further from the model it is extrapolated. And I pause for a moment. We are extrapolating to an absolute extreme. In this case, it is not possible to think of further extrapolation, and that my learned friend urges upon the court, and Mr. Williams urged in the court below. But may I, my lord and lady, I do invite you to look at it in due course. Of course, you'll be coming back to these papers. So at the bottom of page 336, the sentence that is important in my submission is this. Watch observes that deriving risk estimates by extrapolating the H&D model is a straightforward process. Now, again, that's part of my learned friend's criticism that Professor Norrie was mercurial. It's a good paper. It's got some good data. He's not critical of the mathematical approach to extrapolate. It's a straightforward process. Watch tell us. But they go on to say, however, there was a variation of opinions across the committee with no clear majority or consensus view as to the appropriateness of presenting such estimates in numerical form or using them for decision-making in a way that might be taken by others to imply confidence in the numerical accuracy. So decision-making there might take two forms, of course. One, this paper is directed towards employers, what steps they can take, what risk assessments they should put in place, what processes they should have place in their premises. Also, we do take it this way. Decision-making is a court relying upon those estimates. That may or may not have been in the mind of Watch, we're not sure, but I urge upon this court that that's a good way to read it. Whether they meant it or not, we encourage this court to look at that and say, if they tell an employer they shouldn't be relied on for decision-making, how on earth can it be said that they're reliable for decision-making by a court of law to determine the individual rights of somebody who's died? That's what we say about Watch. And that's part of the, our response to my learned friend's assault on Professor Norrie. Now, two or three other matters very briefly on dealing with responding to that assault on Professor Norrie. Remember, of course, as we took the court to before, Professor Jones deferred to Professor Norrie on the question of extrapolation. And again, simply a note without taking my lords and ladies to it in light of the time, supplementary bundle, tab 1, page 305. This is distinguishing the Novartis point, the whose expert's the best point that my learned friend raised. In this case, Jones defers to Norrie on epidemiology. Two more points, if I may. The first is that my learned friend dwelt on and emphasised to you Professor Norrie's inexperience in disease cases. Now, we all start somewhere. We all have our first case, even Mr. Platt had his first disease case once upon a time. But experience in disease is irrelevant to the key issue in this case, which is, can one extrapolate safely? That's not a disease-specific question. So no amount of poking and prodding around peripheral errors, peripheral changes of opinion by Professor Norrie can or should stand to undermine Professor Norrie's central evidence that on a basis of statistics and epidemiology, it is not safe to extrapolate. And the final point is this, as my learned junior has already taken you to, and I therefore won't dwell much further on. Almost all the experts in this case have changed their view about something. whether from their first report to their second, from their second to their joint statement, from their joint statement to the oral evidence. There isn't, I think, a single person in this case, single expert in this case, who has not adjusted their view. And I say that because that's a good thing. Experts are not advocates. They're not hired guns. We don't expect them to stick to a position which is untenable. And in fact, it does nothing other, respectfully submit, invite the court to consider that enhance an expert's credibility and reliability. They move when different data is put to them. And perhaps having failed to consider an issue in sufficient detail is pointed out to them. It's not a point of criticism, it's not a proper point of Norrie bashing, it's a point that in fact commends the expert to the court in my submission. I think I've gone through 3 points. I'm flagging for my Lord Justice Coulson, I'm coming to the last one, which is the inference argument. We won't go over the ground again that we went over yesterday. It is, however, perhaps my shorthand which has led to the concern which we discern from the bench on this point. I said the inference to be drawn is you should prefer Chambers over Steer. That's my shorthand, and I can apologise for it. The inference is a simple inference of fact. The court now knows, because you've been through the material, I understood it clearly, that the difference between Mr. Chambers' figure and Mr. Steer's figure depends on the judge's conclusion of how many days a week the mechanic was exposed to asbestos. And within the days in which he was exposed to asbestos, whether he could treat that as a whole day or a day with peaks and troughs. And what I mean is that by depriving the court and the claimants of air monitoring data, the court should have taken the, sympathetic would be my word, approach that when the witness said he worked for a day with asbestos, it's a day with asbestos. And not gone down the let's modify that with peaks and troughs. Should have looked at an 8-hour day. And that's the inference that should have been drawn from the defendant's failure to provide air monitoring. So I'm not in the airy-fairy land of clinical negligence cases and drawing an inference of causation. I'm not saying that we're going to tie a judge's hands in every case. You're not, by allowing that inference in this case, opening the floodgates for future litigation. On the very specific facts of this case, one of the issues was how much asbestos was the mechanic exposed to. We could have known if air monitoring had taken place. We didn't know because in breach of duty, and I'll come back to the regulations in a moment and I'll make that point good. In breach of duty, the defendant couldn't give the court that information. And I pause for a moment that the defendant is still a going concern and somebody could have been called, no doubt, who'd worked in the business for a number of years. We would expect. But the defendant didn't give that information to the court. The court should therefore have taken a, say, claimant friendly, I don't necessarily mean claimant friendly, I mean a view of the evidence that is favourable to the party who has been deprived of the objective evidence it should have had the defendant not been in breach. So that's what I mean. It's a very limited inference in this case.
Well, that is a different case.
Sorry?
I understand. I understand that's a different case. I'm allowing everybody to say whatever they like, take whatever much time.
I'm grateful. Forgive me, I didn't see it as a different case. Forgive me, my shorthand of preferring.
It's effectively saying
preferring Chambers over Steele.
It's effectively saying that the judge's exercise, the judge shouldn't have done the exercise of interpreting Mr. Russell's statement. It should have been taken at face value, even if the judge thought that that was completely wrong.
Even if the judge thought that was completely wrong.
If the judge, well, he can't have spent 8 hours with asbestos.
Well, forgive me, the judge made a number of assumptions. The judge took a day as being a day, one single day, a Monday, a Tuesday. He doesn't tell us, but the judge's judgment reads as if.
I mean, the judge...
reads as if he thought the mechanic spent 1 day out of 5 dealing with brakes and clutches. Now, that strains credibility, that he would only have had cars and vehicles in with
We're not
brakes.
here to argue about the finding of fact.
Yes.
That's why this inference point is so important.
It is,
It
precisely.
completely changes the whole factual basis on which the judge made the findings as to exposure.
Well, Lord, forgive me for raising my voice.
No.
We are,
I mean,
I think
that's why it's so important.
we are, I think, as one on this point, my lord. Yes, it is very important.
Yeah.
And it may be that my description of it, of prefer chambers over steer, may have mischaracterised by shorthand what I mean, which is that one should not have taken...
I don't think it mischaracterises, as I say, and I put it to Mr. Platt as well, the judge, I think was operating on the basis that that's what he was being asked to do, notwithstanding the fact that he had determined the facts. Because that's 100.
Yes, because in fact drawing the inference is, as I say, it's inept language, and the sense in which it's been used in the cases. One can't say in the 17th.
I mean, effectively, your submission. Sorry to interrupt, but just so that I follow the point through, your submission is that the answer to the judge's point. It does not seem to me to be a sustainable argument that the lack of monitoring should lead the court to adopt uncritically Mr. Chambers' calculations in circumstances where I've concluded that they do not reflect the factual matrix I have found to exist at the relevant time. Your point, which Mr. Platt says is a new one and we'll have to consider that, is, well, you shouldn't have found the factual matrix as you did. The inference is that you should have found the factual matrix to be something different.
Yes, precisely. And forgive me, as I say, I've sought to explain it's not a new point. Perhaps we'll leave that to one side and focus on the substance, if I may. Which is precisely that. If one thinks about it, air monitoring, had it existed, we'll pause again, because Mr. Platt said it's not pleaded. It is.
No, monitoring is pleaded, medical records is not pleaded.
Fine. The point concerns air monitoring, not medical records. The failure to monitor the air is pleaded in the core bundle at page 173.
173.
173.
173, fine.
You don't need to look at it, but it's pleaded crystal clear.
So that's the air monitoring.
That is the air monitoring point is pleaded.
Well, I accept that. It's regulation 16 is not pleaded. That was the
But that's now seems to have been abandoned, as you...
It does, but it affects the retention of records.
Yeah.
If we... Do I need to take the court to it or not? I'll take the chance and say no. The court's already looked at the 1987 regulations, at 4 of the authorities bundle. I don't propose to take you back to those. Mr. Platt is right in one sense, in that the obligation to retain air monitoring records for 40 years only arises if an action level is exceeded. But here is my point. In a sense, Mr. Platt is doubling down on the problematic issue of the adverse inference and their failure to do the air monitoring. We would only know if the action level had been exceeded if they had complied with their legal duty, not been in breach of duty failing, to do air monitoring. So again, exactly on that principle, I say it doesn't lie in Mr. Platt's mouth to say it's for us to prove whether the action level is exceeded or not, because it's their air monitoring that in breach of duty they failed to do that deprives this court and deprives the court below and deprives us all of knowing whether the action level was exceeded. It's part and parcel of the same failure on the defendant's part, the same failure that was there in Keefe and others, the same failure to comply with requirements and legislation, the same breach that puts information not before the court. And if the court had had air monitoring, again, I'm sure the court has the point. We don't suggest for one moment that it would have identified how much asbestos dust the mechanic was exposed to in every year that Elaine worked. Nor does it directly identify how much asbestos dust Elaine would have been subject to. But what it does is
that second point doesn't matter because everybody's agreed that you get to Elaine's exposure from the mechanic's exposure.
Yes, it's the building block, it's the foundation, construction terms upon which the calculation of Elaine's dose is built. We don't have that foundation because of the defendant's breach of duty. Had we had that foundation, we would have known at least for 1 year, and had that been there and available and disclosed as a disclosable document many months prior to the trial, the parties could then have directed their engineering experts to consider differently whether practices had changed. Whether practices had changed to an extent that would have reduced or increased the asbestos levels. But air monitoring, it's difficult to think of anything that is more important in an asbestos case. I cannot imagine better evidence than that, which this court has been deprived of by a breach of duty on the defendant's part. So that's why we say it is a serious and a significant breach. That's why we say it engages the principles in Heath and all those other cases we've talked about. And that is why we say on a very simple level, acceding to the adverse inference that should have been drawn would have led to Mr. Chambers' calculation being accepted, but I'm not simply saying to prefer an expert. It's not a blank scrabble. As Melvin and friends described it, it's fact-specific in this case, which is an assumption that there was a working day's exposure to asbestos, not less than a working day, which is what the judge actually found. So it is key, because if that's right, this is why I opened with it as our first point, if we are right on that, and that Mr. Chambers' figures, which are based on an 8-hour working day, should the inference be drawn, are correct, then as we say in our skeleton, and I won't take the court's time by explaining any further, on any basis we will. And you can go back to the skeleton, my lords and ladies, and see why that is. So that's important. That's the first threshold. If we win on that, we win this case. This appeal. If we win on, as I say, what was ground one, which is why we addressed it second, that it is not safe to extrapolate, and that the judge entirely misdirected himself by considering that it was safe to extrapolate was the view held by Professor Murray. Then again, the judge is presented with a binary choice. The alternative is what, with hindsight now, and in his closing submissions, counsel below, called method one. It's to adopt the Jones evidence. Sorry, the Norrie evidence. Again, the Norrie evidence. It's too late. And again, in those circumstances, for the reasons we presented in the skeleton, we win. Beyond that, the court needs to delve into grounds 2, 3, and 4 of the appeal. I'm not sure that there is, but is there anything further that I can assist the court with?
Not from me. No, thank you very much.
Very grateful.
Thank you very much. All right. Thank you all very much. Those who've made more submissions, those sitting behind you, everybody braving the temperature in this court for 2 days. You'll be unsurprised to learn that we will reserve our judgments and you will get those in the normal way. The normal way is that you'll get a draft. That's for you to comment on the typos and any obvious factual errors, but it is not an excuse to re-argue the case, as you both know. The draft, when we get the corrections back, will then be finalised. That will be handed down electronically, so there's no need to attend. At the same time as that, we would ask, if at all possible, you agree the order consequential upon our judgment, and if you can't, then the best way of doing it is an order with the bits that you disagree in square brackets, and we'll decide that on paper. Finally, in relation to the draft, and I know you all know this, but I have to say it, the draft is confidential, so there are strict rules as to that. We have, I think, a list of counsel and the solicitors who will get a copy of the draft, and as far as the lawyers are concerned, it's limited to them, and for the limited purposes that are set out in the Council of Wales case, the draft can of course be discussed with clients, but for those limited purposes as set out in the case. All right. Thank you very much.
Bye.